call to order. Thank you for attending this public meeting of the United States Sentencing Commission. The Commission appreciates the attendance of those joining us here, as well as hopefully lots of people joining us on our live stream broadcast on the Commission's website. As always, we welcome and encourage the significant public interest which everyone has shown in the sentencing issues. So the first order of business is a vote to adopt the August 7th, 2015 public meeting minutes. Is there a motion to do so?
So moved.
Is there a second?
Second.
Any discussion? All in favor?
Aye.
Anyone against? You'll find out in a minute who the strange voice is coming over the across the meeting room. Those of you who regularly attend our meetings may notice that we are joined by two new faces today, and I'll introduce them in a second. But first, what I want to do is to acknowledge the service of Jonathan Wroblewski, who served as the ex officio member of the Commission representing the Attorney General since 2008. Mr. Wroblewski is currently serving as the acting Principal Deputy Assistant Attorney General, Head of the Office of Legal Policy, what a title, at the Department of Justice. As a result, his new job responsibilities, he will not be serving as the Attorney General's representative to the Commission. Mr. Wroblewski's service to the Commission was exemplary, and he's already deeply missed. We wish him great success in his new position. Now, Michelle Morales, seated to my right, far right, replaces Jonathan as the designated ex officio member of the Commission representing the Department of Justice. Commissioner Morales is the acting director of the Office of Policy and Legislation in the Criminal Division of the Department. She first joined that office in 2002 and has served as its deputy director since 2009. Commissioner Morales previously served as an assistant U.S. attorney in the District of Puerto Rico. Welcome.
Thank you.
Now, seated on my far left, we are also thrilled to introduce the designated ex officio member of the Commission representing the United States Parole Commission. Commissioner Smoot was nominated to the Parole Commission by President Obama and was confirmed by the United States Senate on September 16, 2010. She was designated as chairperson of the Parole Commission effective May 29, 2015. Immediately before joining the Parole Commission, she served as the Deputy State Attorney for Prince George's County, Maryland. Commissioner Smoot has also been an Assistant United States Attorney in the District of Columbia and a Public Defender in Prince George's County, Maryland. We are very happy to have you here. I would also like to tell you about that voice we just heard over the phone. That voice is the voice of Chuck Breyer, our Vice Chair, and he's not able to be present today because we, as we all do, have other lives, and he's a district judge in Northern California and is currently presiding over a criminal case in which the jury is now deliberating.
Well, they've reached a verdict.
Oh, well, no, don't. As a result, he was not able to join us in person, but our rules permit him to join us telephonically. And while he's not here with us today, I would also like to take a moment to acknowledge the service of Rick Holloway, the former vice chair of the Probation Officers Advisory Group. After a long career of distinguished service, Rick is retiring as a federal probation officer, and as a result, he will be stepping down from his role as vice chair of this important advisory group. The Commission is grateful for his contributions, both in his service to his country and all of our country, and as well as his additional contributions to the Commission. In addition, I want to acknowledge Jennifer Bishop Jenkins and Judge Paul Cassell for their second and final terms on the Commission's Victims Advisory Group, who are also not able to be here with us today. Each of them has contributed immensely to our understanding of the needs and perspectives of victims in the federal criminal justice system, and the Commission has benefited significantly from their work. We look forward to opportunities for ongoing collaboration with them. So before we begin, I would also like to highlight the Commission's successful national training seminar in 2015. Approximately 1,000 attendees came to this national training seminar. And also, importantly to note, 100 federal judges appointed within the past 5 years participated in New Orleans. Given the robust attendance and participation in this event, we look forward to continuing a wide range of training activities, including next year's National Training Seminar in Minneapolis on September 7th through the 9th. We hope you all can come. Before we proceed with the other business, I also thought I'd take a few minutes to update folks on the retroactivity of our Drugs Minus 2 amendment from 2014. The amendment and its retroactivity were an important part of the Commission's ongoing policy priority of reducing the cost of incarceration and overcapacity in federal prisons consistent with our statutory obligation and our commitment to public safety. Following a one-year delay in implementation, eligible offenders began receiving early release on November 1st, 2015. To be clear, there were no automatic sentence reductions. Every offender seeking retroactivity was required to seek review from a federal district court judge. In each case, a judge carefully determined whether any reduced sentence was appropriate. In doing so, the court considered all the circumstances and factors in the case, including their behavior in prison, as well as input from the probation service. Throughout the process, there continues to be explicit attention to public safety and deterrence. As of November 1st, 2015, we received and analyzed documentation for 27,824 motions for retroactivity, and the courts granted 21,003, or about three-quarters of them. The average sentence reduction was 23 months, from 130 months to 110 months. And we are informed by the Bureau of Prisons that about 6,000 offenders were released on or about November 1st. The Commission continues to monitor and to review this measure, and the most recent implementation report from last month was posted on our website. At the same time, we continue to look to Congress to fully address the issue of excessive federal prison populations and costs through re-examination of existing statutory mandatory minimum penalties, particularly related to drug crimes. As in the past, we continue to strongly support bicameral, bipartisan congressional action to address these pressing issues, which will then help us in deciding our ongoing work. With that was a mouthful, a lot to say, but there's more, and I would like to turn to Ken Cohen to deliver the staff director's report on other commission announcements and activities.
Thank you, Judge. I'd like to introduce two new members of our senior staff who will have a lot of interaction with the public going forward. For those of you who follow the commission, you know that Raquel Wilson, who's seated right behind me, has been our acting director of the Office of Education and Sentencing Practice since February of 2015. And in November, she agreed to accept that position on a permanent basis. Prior to moving to the Office of Education and Sentencing Practice, she served as Deputy General Counsel here at the Commission from September 2009 to February 2015. She joined the Commission after several years of experience as an Assistant Federal Public Defender, first in the Southern District of Texas, and then the Western District of North Carolina. She received her law degree from Stanford Law School and her BA from Rice University. She and Alan Dorhofer, the Deputy Director of the office, make an excellent management team for that unit. Secondly, for those of you who follow federal criminal justice issues, I'd like to introduce Christine Leonard. She should not be also seated behind me, not a stranger to. She's our new director of the Office of Legislative and Public Affairs. Christine served as senior counsel on the staff of the Senate Judiciary Committee working for Senator Kennedy from 2005 to 2008, and as associate director in the Office of Legislative Affairs in the White House Office of National Drug Control Policy from 2009 to 2011. After leaving government service, she was director of the Vera Institute of Justice's Washington office from 2011 to 2015, and most recently served as executive director for the Coalition for Public Safety. Christine received both her undergraduate and her law degree from Boston College, and she and Sekemi Monioni complete our newly revamped legislative team. So welcome.
Welcome. So the first item of business is a possible vote to promulgate a crime of violence amendment, and I will now ask the General Counsel to advise the Commission on the vote to promulgate a crime of violence amendment.
Thank you, Judge. This proposed amendment is a result of the Commission's multi-year study of statutory and guideline definitions relating to the nature of a defendant's prior conviction, and is informed by the Supreme Court's recent decision in Johnson v. United States. The proposed amendment amends the definition of crime of violence in 4B 1.2 A2 in three ways. First, it amends 4B 1.2 4B1.2A2 to delete the residual clause. Second, it amends 4B1.2A2 to revise the list of enumerated offenses and move that list from the commentary to the guideline. The offenses on the revised list are murder, voluntary manslaughter, kidnapping, aggravated assault, forcible sex offense, robbery, arson, extortion, or the use or unlawful possession of a firearm described in Title 26 United States Code, Section 5845A, or an explosive material as defined in 18 United States Code, Section 841C. Conforming changes to the commentary are also made. Third, it amends the commentary to add definitions for the enumerated offenses of forcible sex offense and extortion. As defined, forcible sex offense includes where consent to the conduct is not given or is not legally valid, such as where the consent to the conduct is involuntary, incompetent, or coerced. The offenses of sexual abuse of a minor and statutory rape are included only if the sexual abuse of a minor or statutory rape was either an offense described in 18 United States Code, Section 2241C, or an offense under state law. It would have been an offense under that section if the offense had occurred within the special maritime and territorial jurisdiction of the United States. Extortion is defined to mean obtaining something of value from another by the wrongful use of either force, fear of physical injury, or threat of physical injury. Finally, the proposed amendment includes two departure provisions. First, it provides an upward departure provision in 4B1.2 to address certain cases in which the instant offense or a prior felony conviction was a burglary involving violence. Second, it provides a downward departure provision in 4B1.1 for cases in which one or both of the defendant's two prior felony convictions is based on an offense that was classified as a misdemeanor at the time of sentencing for the instant federal offense. And that is a misdemeanor by the state of jurisdiction. A motion to promulgate the amendment with an effective date of August 1st, 2016, and with technical and conforming amendment to authority to staff is appropriate at this time.
Thank you. Is there a motion to promulgate the proposed amendment?
I so move.
Is there a second? Second. Is there any discussion on the motion?
I had a comment. The Department of Justice wants to thank the Commission for addressing this issue, which we had flagged was critically important. We are particularly pleased that the Commission is eliminating the residual clause, which had long been problematic in its application and was further complicated by the Supreme Court's holding in Johnson v. United States. However, we had advocated for additional changes, including the elimination of the categorical approach in favor of a conduct-based approach, as well as the inclusion of additional enumerated offenses to include carjacking, hostage-taking, and others. We believe those measures would have made the classification of violent crimes simpler and more predictable, and we are a little disappointed that more of these recommendations were not adopted. We do hope that the Commission will closely monitor the impact of these amendments to ensure that they indeed capture the most dangerous offenders, but we look forward to continuing to work with the Commission on the remaining amendments.
Thank you, Commissioner Morales. Anything else? As we normally do each January, in a few minutes, the Commission will vote on whether to publish a number of proposed amendments for this amendment cycle. As a reminder, those proposed amendments are just preliminary proposals that we put forward for public comment, and I'll talk about them a little later. But at this point, we are considering a vote to promulgate a set of amendments to the current guideline definitions relating to the nature and impact of a defendant's prior convictions for a crime of violence. These amendments stem from the proposed amendment we published for comment in August. As I said then, those of you who regularly follow the Commission's work know that publishing in August and promulgating an amendment today is different from our usual practice. Nonetheless, we felt that it was appropriate to take action as soon as possible in light of ongoing litigation in this area and the added uncertainty resulting from the Supreme Court's recent decision in Johnson versus United States. In Johnson, the Supreme Court struck down as unconstitutionally vague a portion of the statutory definition of violent felony used in a similar penalty provision in the Armed Career Criminal Act, which many people just call ACCA. While the Supreme Court in Johnson did not consider or address sentencing guidelines, the statutory language the court found unconstitutionally vague, often referred to as the residual clause, is identical to language contained in the career offender sentencing guideline. As noted in August, since the Johnson decision, we have been considering whether, as a matter of policy, the Commission should also eliminate the residual clause in the guidelines. The amendment we are considering today would do just that by eliminating the residual clause in the career offender guideline definition of crime of violence. In its place, the proposal would provide a list of specific enumerated offenses that qualify as a crime of violence, and for easier application moves the entire list into the guidelines. While a few select definitions are provided, as you just heard, the proposed amendment would continue to rely on long existing case law for purposes of defining the enumerated offenses. In addition, the amendment also includes a departure provision that allows courts to depart in cases in which the predicate offenses were classified as a misdemeanor under the laws of the convicting jurisdiction. While we view these potential amendments as significant, this is not necessarily our final work in this area. This is a very complex, important area of law that continues to evolve and garner a great deal of discussion, and we intend to continue to study recidivist enhancements in the guidelines throughout the upcoming amendment cycle. For example, we plan to publish a report on career offenders and other recidivist provisions later this year, which could include recommendations to Congress for statutory changes. Finally, as part of our broader look at the immigration guidelines, we are continuing to consider whether conforming changes should be made in the illegal reentry guidelines treatment for enhancement based on prior convictions. So I think we're ready now for the vote. All in favor of the amendment?
Aye. Aye.
Anyone against? Aye. It carries.
And let the record reflect that at least 4 commissioners voted in favor of the motion. The amendment before the Commission just promulgated may have the effect of reducing the term of imprisonment recommended in the guidelines applicable to a particular offense or category of offenses. As such, the Commission has statutory authority under 28 United States Code, Section 994U, to make this amendment retroactive. Is there a motion pursuant to Rule 2.2 of the Commission's Rule of Practice and Procedure to instruct staff to prepare a retroactivity impact analysis for the crime of violence amendment that you just promulgated? Hearing no motion, this will fail for lack of a motion.
Thank you. I do want to briefly discuss the topic of retroactivity, as I am aware that several commenters have asked the Commission to make any changes in this area retroactive. In deciding whether to make an amendment retroactive, the Commission considers several factors, including 1, the purpose of the amendment, 2, the magnitude of the change, and 3, the difficulty of applying the amendment retroactively. While the potential change in the applicable guideline range could be significant for individual defendants, the amendment's purpose is to address the complexity of the guideline definition and reduce litigation associated with the crime of violence definition in the career offender guideline. With respect to relevant facts, it would be extremely difficult to identify those offenders who might be retroactively impacted by the elimination of the residual clause. Specifically, 2 major data limitations would preclude staff from being able to complete a retroactivity analysis of this proposed amendment. First, our sentencing documentation does not consistently report, and the Commission data does not include information about which prong of the crime of violence definition at 4B1.1 was applied. Therefore, staff cannot identify cases in which the residual clause alone qualified an offender for the career offender provision. Similarly, sentencing documentation does not consistently report which criminal history events the court used as the predicates in order to apply the guideline. Furthermore, a predicate that was counted under the residual clause still may qualify under another prong of the crime of violence definition, such as the elements clause. Under these circumstances, it is difficult, if not impossible, to ascertain the overall effect of the various amendments and would likely make retroactive application complex and time-intensive. The very issue of retroactivity is already being litigated. As a result, the Commission has determined that a meaningful and complete retroactivity analysis is not possible. As I mentioned earlier, the Commission is continuing to evaluate the career offender guideline, We acknowledge this is a very complicated area of law that continues to challenge courts and litigants alike. So we will continue to study this issue, and we plan, as I said earlier, to issue a report to Congress later this year. So the next item of business is a possible vote to publish in the Federal Register proposed guideline amendments and issues for public comment. And the General Counsel will advise the Commission on the first possible vote concerning a proposed miscellaneous amendment.
Thank you, Judge Saris. The first amendment before you for your consideration is the miscellaneous amendment package, which responds to recently enacted legislation and miscellaneous guideline issues. The amendment has 4 parts. Part A of the proposed amendment responds to the act commonly referred to as the USA Freedom Act of 2015, which, among other things, set forth changes to statutes relating to maritime navigation and provided new and expanded criminal offenses to implement certain provisions in international conventions relating to maritime and nuclear terrorism. The Act also added these new offenses to the list of offenses specifically enumerated in 18 United States Code Section 2332BG5 as federal crimes of terrorism. The new offenses cover a broad range of conduct, and Part A of the proposed amendment addresses these new offenses at Section 2280A by referencing them in Appendix A to a variety of Chapter 2 guidelines. In addition, the USA Freedom Act created a new criminal offense at 18 United States Code Section 2232I. 2232I has penalties of up to $2 million in fine and imprisonment for any term of years or life, and also covers a variety of different criminal conduct. Part A of the proposed amendment amends Appendix A to reference the new offenses in 18 United States Code Section 2232I to 286.1, 2K1.4, 2M2.1, 2M2.3, and 2M6.1. Finally, Part A makes clerical changes to reflect redesignation of a section in the United States Code by the Freedom Act, USA Freedom Act. Part A also includes 2 issues for comment. Part B responds to the Bipartisan Budget Act of 2015, which, among other things, amended 3 existing criminal statutes concerned with fraudulent claims under certain Social Security programs. Those sections are 208, 811, and 1632 of the Social Security Act. Those are currently referenced in Appendix A to 2B1.1, which is the theft and fraud guideline. The Act added new subdivisions criminalizing conspiracy to commit fraud for these selected offenses. Part B amends Appendix A so that those sections of the Social Security Act are referenced not only to 2B1.1 in the guidelines, but also 2X1.1, and Part B of the proposed amendment includes issues for comment. Part C addresses violations of Section 1715 of Title 18 United States Code, which makes it unlawful to deposit for mailing or delivery by the mails pistols, revolvers, and other firearms capable of being concealed on the person and declared non-mailable by Postal Service regulations. For any violation of that section, the statutory maximum term of imprisonment is 2 years. The current guidelines manual does not include a guideline reference in Appendix A for these offenses. Part C of the proposed amendment amends Appendix A to reference these offenses to 2K2.1, the firearm guideline. It also adds 18 United States Code Section 1715 to subsection A8 of 2K1.1, establishing a base offense level of 6 for such offenses. Part C also includes an issue for comment regarding these offenses and asks whether other changes to the guidelines are appropriate to address them. And finally, Part D of the proposed amendment amends the background commentary to 2T6.1 to delete a sentence relating to violations of 26 United States Code, Section 7202, that states the offense is a felony that is infrequently prosecuted. A motion to publish the proposed amendment with a public comment period closing on March 21st, 2016, and technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion?
So moved.
Is there a second? Second. Any discussion? Maybe you could repeat all. Is there any discussion? All in favor?
Aye.
Anyone against? All right, the motion carries.
Unfortunately, I have to leave because of a jury issue. However, I just want to note it for the record that I support the whole series of proposed amendments for comment.
All right. Thank you. The record will so note.
Thank
And also
you.
let the record reflect that at least 3 commissioners are required to vote in favor of a motion to publish, and at least three did vote in favor of the last motion. Yes. The next amendment for your consideration is the compassionate release amendment. The proposed amendment contains 2 parts. Part A sets forth a detailed request for comment on whether any changes should be made to the Commission's policy statement at 1B113, which is titled Reduction in Term of Imprisonment as a Result of a Motion by the Director of the Bureau of Prisons, or as we commonly refer to, a compassionate release. Among other things, the issues for comment ask whether the Commission should amend the current policy statement, describing what constitutes extraordinary and compelling reasons, whether the Commission should revise 1B113 to address recommendation in the Department of Justice Office of the Inspector General's report on the BOP's implementation of the Compassionate Release Program provisions related to elderly inmates, and whether the Commission should further develop the policy statement at 1B113 to provide additional guidance concerning the circumstances in which sentences may be reduced as a result of a motion by the Director of the Bureau of Prisons. Part B illustrates one possible set of changes to the policy statement at 1B113 that the Commission could make. It would revise the list of extraordinary and compelling reasons for compassionate release consideration in the commentary to 1B113 to reflect the criteria currently set forth in the Bureau of Prisons program statement. The language used in this part parallels that language. A motion to publish the amendment with a public comment period closing on March 21st, 2016, and technical and conforming amendment authority to staff is appropriate at this time.
Do I hear a motion? So move. Second?
Second.
Any discussion? All in favor?
Aye.
Anyone opposed? Thank you.
The motion
Next
carries with at least
motion
3
carries.
voting in favor. The next amendment for your consideration is an amendment to the conditions of probation and supervised release. This proposed amendment revises, clarifies, and rearranges the conditions of probation and supervised release found in certain parts of Chapter 5 of the guideline. It results from the Commission's multi-year review of federal sentencing practice relating to these conditions. The changes made by the amendment would revise, clarify, and rearrange the conditions of probation and supervised release, specifically intended to make them more focused and precise, as well as easier for defendants to understand and probation officers to enforce. For some conditions that do not currently have a mens rea standard, a knowing standard is inserted. First, the proposed amendment amends the mandatory conditions set forth in subsection A of sections 5B1.3 and 5D1.3, inserting new language directing that if there is a court-established payment schedule for making restitution or paying a special assessment, that the defendant shall adhere to the schedule. This language is similar to paragraph 14 of the standard conditions. Accordingly, paragraph 14 of the standard conditions is deleted. Second, the proposed amendment amends the standard conditions set forth in subsection C of 5B1.3 and 5D1.3. Paragraphs 1 through 3, 5 through 6, and 9 through 13 are revised, clarified, and rearranged into a new set of paragraphs 1 through 12. Paragraph 13 is added, which provides that the defendant must follow the instructions of the probation officer related to the conditions of supervision. Several provisions are moved from the standard conditions list to a special conditions list and vice versa. Specifically, paragraph 1 of the special conditions list relating to the possession of a firearm or dangerous weapon is moved to the standard conditions list. Paragraphs 4 and 7 of the standard conditions list relating to support of dependents and child support and alcohol use respectively are moved to the special conditions list. In addition, paragraph 14 on the standard conditions list is incorporated into the mandatory conditions list. Finally, paragraph 8 of the standard conditions list is deleted. Third, the proposed amendment adds 2 new provisions to the special conditions set forth in subsection D of 5B1.3 and 5D1.3. The first new provision, based on paragraph 7 of the standard conditions, would specify that the defendant must not use or possess alcohol. The second new provision, based on paragraph 4 of the standard conditions, would specify that if the defendant has one or more dependents, the defendant must support his or her dependents, and if the defendant is ordered by the government to make child support payments or to make payments to support a person caring for a child, the defendant must make payments and must comply with the other terms of the order. Issues for comment are also included. A motion to publish this amendment with a public comment period closing on March 21st, 2016, and technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Do I hear a motion? Second?
Second.
Any discussion? All in favor?
Aye.
Anyone who's opposed? All right, it carries by the all votes.
Yes, Judge, thank you. The next amendment for your consideration is the Animal Fighting Amendment. This proposed amendment revises 2E 3.1 to provide higher penalties for animal fighting offenses and to respond to two new offenses relating to attending an animal fighting venture established by Section 12308 of the Agricultural Act of 2014. Animal fighting ventures are prohibited by the Animal Welfare Act, 7 United States Code Section 2156. It prohibits a wide range of conduct relating to animal fighting ventures, and any violation of this section, statutory maximum term of imprisonment is 5 years. However, there are two new types of animal fighting offenses added by the Act that make it unlawful to knowingly attend an animal fighting venture or cause an individual under the age of 16 to attend an animal fighting venture. The statutory maximum is 3 years for the first, for causing an individual under 16 to attend an animal fighting venture, and 1 year if the offense of conviction is attending an animal fighting venture. Currently, all offenses under 2156 are referenced in Appendix A to the gambling guideline at 2E 3.1. The proposed amendment revises 2E 3.1 to provide a base offense level of 14 or 16, those are bracketed, if the offense involved an animal fighting venture. And I would note that the last time that the Commission acted on animal fighting offenses, that particular offense had a statutory maximum of 3 years, which was later increased to 5. And so the offenses that would get that higher base offense level of 14 or 16 are the ones with the 5-year stat max. The proposed amendment responds to the two new offenses with the 3 and 1 year statutory maximum relating to attendance at an animal fighting venture by establishing new base offense levels for those offenses. First, a base offense level of either 8 or 10, and those are in brackets in 2E 3.1, would apply if the defendant was convicted under the section that caused an individual under the age of 16 to attend an animal fighting venture. The Class A misdemeanor at Section 2156A2A would not be referenced in Appendix A to the gambling guideline at 2E 3.1. Instead, it would receive a base offense level of 6 in 2X 5.2, which is the Class A misdemeanor guideline. Finally, the amendment revises the existing upward departure provision to cover not only offenses involving exceptional cruelty, but also offenses involving animal fighting on an exceptional scale. Issues for comment are also included. A motion to publish the amendment with a public comment period closing on March 21st, 2016, and technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Do I hear a motion? So moved. Second? Second. Any discussion? All in favor? Aye. Anyone opposed? The ayes carry.
The next amendment for your consideration is the Child Pornography Circuit Conflicts Amendment. This proposed amendment addresses circuit conflicts and application issues that have arisen when applying the guidelines to child pornography offenses. First, the proposed amendment responds to differences among the circuits. In cases in which offense involves minors who are unusually young and vulnerable, such as infants and toddlers, there are differences among the circuits over whether the vulnerable victim adjustment in Chapter 3 of the Guideline Manual applies when the victim is extremely young, such as an infant or toddler, in light of the fact that the Child Pornography Guideline includes age-related enhancements. The Ninth and Fifth Circuits have permitted simultaneous application of the under 12 enhancement and the vulnerable victim adjustment under certain circumstances, but the Fourth Circuit, in contrast, has not. and has explicitly stated that the two adjustments may not be applied. The proposed amendment generally adopts the approach of the Fifth and Ninth Circuits. It amends the commentary in the child pornography guidelines to provide that application of the age enhancement does not preclude the application of the vulnerable victim adjustment. Specifically, if the minor's extreme youth and small physical size make the minor especially vulnerable compared to most other minors under the age of 12, 3A 1.1b applies, assuming that the mens rea requirement of that section is also met. Second, the proposed amendment responds to differences among the circuits in applying the tiered enhancement for distribution in 2G 2.2b3, which provides an enhancement ranging from 2 to 7 levels depending on specific factors. There are circuit conflicts relating to the application of the two-level distribution enhancement, in which the 5th, 10th, and 11th circuits have held that the enhancement applies if a defendant used a file-sharing program, regardless of whether he did so purposefully, knowingly, or negligently. 2nd, 5th, 4th, and 5th circuits, in contrast, have held that the two-level distribution enhancement requires a showing that the defendant knew or at least acted in reckless disregard of the file-sharing properties of the program. Other circuits appear to follow somewhat different approaches. The proposed amendment generally adopts the approach of the 2nd, 4th, and 5th circuits. It amends subsection B3F to provide that the two-level enhancement requires knowing distribution by the defendant. As a conforming change, the proposed amendment also revises the two-level distribution enhancement at 2G 2.1b3 to provide that the enhancement requires that the defendant knowingly distributed. The 5-level distribution enhancement at subsection B3b applies if the offense involved distribution for the receipt or expectation of receipt of a thing of value, but not for pecuniary gain. The circuits have taken different approaches to this issue of what a thing of value. Different approaches to this issue. The 5th Circuit has indicated that when the defendant knowingly uses file sharing software, the requirements of the 5-level enhancement are generally satisfied. The 4th Circuit appears to have a higher standard. The proposed amendment revises subsection B3b to clarify that the enhancement applies if the defendant distributed in exchange for valuable consideration. Specifically, this means that the defendant agreed to an exchange with another person under which the defendant knowingly distributed to that person for the specific purpose of obtaining something of valuable consideration from that other person, such as other child pornographic material, preferential access to child pornographic material, or access to a child. A motion to publish the amendment with a public comment period closing on March 21st, 2016, and technical and conforming amendment authority to staff is appropriate at this time.
Do I hear a motion?
So moved.
Is there a second?
There's second.
Any discussion? All in favor?
Aye.
Anyone opposed? Motion carries. And I think we just all got, what did we just get, Toby? A revised?
Some of the copies were not copied properly, and we're just making sure you have the right copies.
Okay, so if you all saw a flutter, we're just getting them the correct copies. All right, so for our last amendment.
Yes, the last amendment is a proposed immigration amendment, and this amendment is a result of the Commission's multi-year study of the guidelines applicable to immigration offenses and related criminal history rules. The Commission is publishing this proposed amendment to inform the Commission's consideration of these issues. The proposed amendment contains 2 parts. The Commission is considering, or the amendment provides that you are considering whether to promulgate any or both of these parts, as they are not necessarily exclusive. Part A of the proposed amendment would revise the alien smuggling guideline at 2L 1.1. The Commission has received comments expressing concern that the guideline provides for inadequate sentences for alien smugglers, particularly those who smuggle unaccompanied minors. The proposed amendment revises the alternative base offense levels at 2L 1.1 and provides 2 options. Option 1 would raise the base offense level at subsection A3 from 12 to 16, and I note 16 is in brackets. Option 2 adds an alternative base level of 16, also bracketed, if the defendant smuggled, transported, or harbored an unlawful alien as part of an ongoing commercial organization. The proposed amendment also addresses offenses involving unaccompanied minors and alien smuggling offenses. The proposed amendment would amend 2L11 to address the issue of unaccompanied minors. First, it amends 2L1.1B4 to make the enhancement offense-based with a mens rea requirement as opposed to exclusively defendant-based. The proposed amendment would also amend the commentary to 2L1.1 to clarify that the term serious bodily injury included in subsection B7B has the meaning given to that term in the commentary to 1B1.1, which states, serious bodily injury is deemed to have occurred if an offense involves conduct constituting criminal sexual abuse under sections 2241 or 2242 of Title 18 of the United States Code, or any similar offense under state law. Finally, the proposed amendment would revise the definition of minor for purposes of the unaccompanied minor enhancement at 2L1.1B4 and change it from minors under the age of 16 to minors under the age of 18, and 18 is in brackets. The proposed amendment also brackets the possibility of including a new departure provision in the commentary to 2L1.1 for cases in which the offense involves smuggling, transporting, harboring of 6 or more unaccompanied minors. Part B is also informed by the Commission's recent report on offenses sentenced under 2L1.2, which is the illegal reentry guideline. Part B would amend that guideline to lessen the emphasis on pre-deportation convictions by providing new enhancements for more recent post-reentry convictions and a corresponding reduction in the enhancements for past pre-deportation convictions. The enhancement for these convictions would be based on a sentence imposed rather than on the type of offense, for example, crime of violence. In other words, the proposed amendment would eliminate the use of the categorical approach for predicate felony convictions in 2L1.2. Also, the proposed amendment accounts for prior convictions for illegal reentry separately from other types of convictions. First, it amends subsection A of 2L1.2 to provide alternative base offense levels of 14 and 12, in brackets, if the defendant had one or more prior convictions for illegal reentry offenses under 18 United States Code sections 1253, 1325A, or 1326. For defendants without such prior convictions, the proposed amendment increases the otherwise applicable base offense level of 8 to 10. The alternative base offense levels at subsection A apply without regard to whether the prior conviction receives criminal history points under Chapter 4 of the guidelines. Second, the proposed amendment changes how subsection B1 accounts for pre-deportation convictions, again, basing them not on the type of offense, but rather on the length of the sentence imposed for the felony conviction. The proposed amendment incorporates these new enhancements in subdivision A through C at subsection B1. Third, the proposed amendment would permit prior convictions to be considered under subsection B1 only if they receive criminal history points under Chapter 4. To account for the post-reentry criminal activity, the proposed amendment inserts a new subsection B2, which provides a tiered enhancement for a defendant who engaged in criminal conduct resulting in a conviction of one or more felony offenses after the defendant's first deportation or first order of removal. The structure of the new subsection B2 parallels the proposed changes to subsection B1, both in terms of the sentence length required and the level of enhancement to be applied. As with subsection B1, prior convictions would be considered under subsection B2 only if they receive criminal history points under Chapter 4. Finally, the proposed amendment provides a new departure provision for certain cases in which the defendant was previously deported on multiple occasions not reflected in prior convictions, revises existing departure provisions, and brackets the possibility of deleting certain commentary in that guideline. The amendment would make conforming changes to the application notes and issues for comment relating to these changes and possible other changes in the event the Commission decides not to proceed with these full-scale revisions, but rather maintain the current guideline to conform with the career offender changes you just made are also included. A motion to publish the amendment with a public comment period closing on March 16, 2016, and technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Do I hear a motion?
So moved. Second?
Second.
Any discussion on this? All in favor?
Aye.
Anyone opposed? The amendment carries, will be published. I want to briefly address this year's proposed amendments. First, we are publishing a proposed amendment on immigration-related offenses. The Commission has received comment expressing concern that the guidelines provide for inadequate sentences for aliens smugglers, including those who bring in unaccompanied minors. As soon as possible, the Commission will include a data presentation on the Commission's website to inform public comment on this proposed amendment. For those interested in obtaining this information, you can subscribe to our email list or Twitter account to receive a notification when this information is posted. Separately, we are proposing a series of other amendments. First, there's an amendment that revises the guideline pertaining to animal fighting. The proposed amendments would allow for higher penalties for animal fighting offenses in response to the enactment of 2 new crimes relating to attending an animal fighting venture, particularly in cases where a child under 16 is brought to one of these events. The proposed amendment also revises the existing upward departure provision to cover not only offenses involving exceptional cruelty, but also offenses involving animal fighting on an exceptional scale. The Commission's proposed amendment for public comment on supervised release is a result of a collaboration with the Criminal Law Committee, which has studied the current conditions in light of recent court precedent, as well as the Commission's own multi-year review of federal sentencing practices relating to conditions of probation and supervised release. In general, the Commission seeks to make the conditions more tailored to a defendant's needs and problems, as well as easier for defendants to understand and probation officers to enforce. Each year, the Commission considers resolving circuit splits emerging from conflicting interpretation of the guidelines by the federal courts. That's pursuant to statute. This year, the Commission has put forward an amendment to address circuit splits dealing with child pornography offenses. One of the issues typically arises under both the child pornography production guideline and the child pornography distribution guideline when the offense involves victims who are unusually young and vulnerable. Another issue typically arises when the offense involves a peer-to-peer file sharing program or network. These issues were noted by the Commission in its 2012 report to Congress on child pornography offenses. The Commission is also publishing a proposed amendment on compassionate release that seeks further comment on whether changes should be made to the Commission's policy statement found in the guidelines, and if so, how. The proposed amendment contemplates changes to the Commission's policy statement that would revise the list of extraordinary and compelling reasons for an offender to be considered for compassionate release. Lastly, as always, the Commission is publishing a proposed amendment to respond to recently enacted legislation and other guideline issues where an upgrade was both appropriate and timely. I mentioned earlier that the need for the Commission to work to make the guidelines more effective and more efficient. We hope that these amendments will do that, and we will continue to provide updates about further opportunities for public comment in future meetings and hearing through its website and through our Twitter account. We feel so modern with our Twitter account. Please note that the Commission will hold its next public hearings on February 17th, that's February 17th, and March 16th. Again, I thank you for your interest in these important issues, and I look forward, as always, to your further comments and feedback from the public. And I just emphasize this, we really read everything. We really do, and we discuss it. And whenever you get it to us, that's great, but please try and get it to us on time, because that's really when we're able to digest it the best and then incorporate it into the amendment. So some people are late flyers, shall we say. They're just as the gate's closing. Well, that's harder to read the stuff thoroughly, so please get it to us on time. Is there any further business before the Commission? Hearing none, is there a motion to adjourn?
I move to adjourn.
Opposition? Do I hear a second? All in favor? Aye.
Aye.
Anyone who's opposed? No. We are adjourned. Thank you. There's a lot of work that went into today. I really want to thank staff for all the work that went in. It was huge. And so I look forward to hearing from all of you about our amendment. Thank you.